Assalamu alaikum and welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia. This is the second part to the show. Just before the break, we were looking at the problems which occur within marriages, and in particular where somebody who's acquired a spouse visa to come to the United Kingdom managed to then obtain indefinite leave to remain, and then the marriage breaks down. And we had a caller who wanted to inquire about whether there's anything that can be done. Assume what the idea was to try and get the Home Office to send the husband or wife back to their home country. So we looked at that in depth. Basically what I was saying was that where somebody has indefinite leave to remain in the United Kingdom, your options are very much limited, and at the same time we looked at those people who had to leave their marriage because there's problems, etc., and how there are rules which to some extent, albeit a limited extent, protects them as well, where they have been the victim of domestic violence, or they've been in a marriage where there are children and they've either got residence order for the children or they're having contact with the children. So there are laws which, despite the marriage breaking down during the initial probationary period, there are laws which protect those people as well. And what I then looked at is under European laws, where somebody who's come here, not under the UK immigration rules, but where the sponsor has a European passport and they've come here under the European laws as a spouse, again, there are laws which protect in that situation as well. So just going back to the sort of topic for the day, we were looking at how European laws are different when somebody wants to come to the United Kingdom to our standard UK laws. So for example, a person of Pakistani origin is here in the UK, has an Italian passport, German passport, etc. They want to sponsor their husband or wife to the UK. What I was looking at is how much easier it is, and one of the things that I looked at is that there is, first of all, fundamental difference is that there's no English test that needs to be passed. We'll look at that in greater detail after we've taken our next call. Hello, assalamu alaikum.
Assalam, brother.
Thank you for calling.
Brother, I want to ask a question on behalf of one of my friends.
Right, okay. Okay.
Right, basically he's got a student visa, he's come over on a student visa.
Right, okay.
And he's got caught driving.
Okay.
And he's been worried about it. Is that going to affect him?
All right, okay, right. Thank you very much for your call. Let me go through that in detail, but thank you very much for calling.
Thanks, sir.
Now, we'll take our next call, but we'll return to this as well after we've dealt with the next call. Hello, assalamu alaikum.
Walaikum salam, brother. My name is Zafar Ali Khan.
Ji, Zafar,
and I came to UK last year.
Right.
I'm from Pakistan originally.
Okay.
And my question is that I'm actually allowed to work on my student visa. I'm only allowed to work 20 hours.
You're right. Okay.
So if it's possible that if I can work at two different places on 20 hours, because it's going to be calculated altogether to 40 hours. So this is my question. Thank you.
Right, okay, brother. Thank you very much for your call. Let me just deal with that first and then go back to the call that we had before. In terms of a student who comes to the United Kingdom, there are some students who are allowed to work, some students aren't allowed to work, and a lot depends on the place where they are studying and the level of the course that they are studying. And this particular caller, he is permitted to work, and it's up to 20 hours a week. Now, it isn't possible to do 20 hours in one place and 20 hours in another place. It's a total of 20 hours that the students are able to work in this particular situation. So 10 hours in one place, 10 hours in another place, that's absolutely fine. So it has to be that the hours cannot exceed 20 hours a week. And what the Home Office does do is look at the week in total and look at how many hours somebody has done. And if it exceeds 20 hours, then potentially it is a problem in that there is a breach of the immigration rules. Having said that, what the visa conditions will say is that outside term time, it is possible for students to work full time. So the restriction in terms of 20 hours a week, that restriction only applies to term time working. Outside term time, it's possible for the student to work full time. Now, how do you work out term time? How do you work out non-term time? What the Home Office does is that it looks at the university's academic calendar. And a lot of the times you find that there is an academic calendar actually on the university's website, and it will tell you when the different semesters are, when the different terms are, and it will tell you which weeks are let's say term time weeks and which weeks aren't. So you have to follow your own university's term time or non-term time academic table, and it's based on that determines whether the 20-hour restriction applies because it's term time, or whether no restriction applies and you can work full-time. Effectively full-time could mean 40 hours, 50 hours, 60 hours. There's no restriction at all. But specifically in answer to the question, during term time it has to be a total of 20 hours. Wherever you work, whether it's company A, company B, company C, it cannot exceed 20 hours a week. Outside term time, obviously there's more flexibility. Let me take our next call. Hello, Assalamu alaikum.
Hello, Assalamu alaikum, brother. My name is Aziz Ahmad. And I would like to ask you, can you please elaborate what is the European written right? If you can.
Brother, sorry, European?
Written right.
So, sorry, I didn't catch you. European, sorry, I have to. Retained rights. Sorry, I do apologize. European retained rights, I think you were saying. No?
Yes.
No problem, brother. Let me deal with that. I'll take you through that. European retained rights, and this is something which a lot of lawyers are now having to deal with as a result of people being granted European visas, and then potentially there being a problem, which means that the original European visa that they've been granted, the circumstances under which that original visa was granted no longer exists. However, the rules permit them to remain in the United Kingdom, even though the original circumstances do not exist. So you have a category called retained rights. There are other categories as well, derivative rights, etc., which we won't look at. But let's look at retained rights. Let's look at the most popular sort of example that one comes across, which is normally where somebody's been granted a European visa as a husband or wife. They're married, they're in the United Kingdom, living together. Unfortunately, there comes a time when the marriage breaks down and they obtain a divorce. So in that situation where there's a divorce, in certain circumstances, even though there's been a divorce, the partner of the European passport holder still has the right to continue living in the United Kingdom, hence retained rights. The rights to continue living in the United Kingdom are retained despite the fact that the circumstances have now changed. The marriage has broken down. But there are, as you would expect, certain very strict requirements which would need to be fulfilled before somebody has the retained rights to continue living in the United Kingdom. If you look at the typical example, and we're looking at the spouse example here, the first requirement is that the parties need to have been married for 3 years. Wherever they got married, the requirement is that they must have been in a relationship as a married couple for 3 years. So these are the requirements that need to be fulfilled before you can rely on the retained rights category under the European rules. So if you're married for 3 years. Secondly, you must have lived with your European partner in the United Kingdom for at least 1 year. So potentially you could have lived 2 years outside the UK, it could have been India, Pakistan, anywhere in Europe. But as long as you've lived for 1 year in the United Kingdom, you meet that requirement. So you've been married for 3 years, you've lived in the UK for at least 1 year. The next requirement is that when the application for divorce is finalized, when the decree absolute is received, as at that date, the European passport holder needs to be working in the United Kingdom. And then after that, there's no longer a requirement for the European sponsor to be working. You need to be working yourself. So if we run through that, you've been married for 3 years, you've lived in the UK for 1 year, as at the date the application for divorce is made. When the decree absolute is received, because you've marriage has broken down, we've applied for a divorce, you've got the decree absolute. As at the date of decree absolute, your European sponsor is working, and then after that, you yourself are exercising treaty rights, which normally means you're working or you're self-employed. So if those requirements are fulfilled, then it is possible for the person who's married the European sponsor, for that person to continue living in the United Kingdom, despite the fact that the marriage has broken down, and the marriage has broken down within the first 5 years. So it's possible if those conditions are satisfied. Now, the key thing here, very much with all European applications and very much with other applications, is that there has to be evidence which supports all of these points. It's easy to demonstrate you're married because you need a marriage certificate. Then you need to demonstrate you've lived in the UK for 1 year. So you'd need bills, evidence of sponsor working. You have to prove that you've been in the UK, maybe stamps in the passport. Where the problem normally occurs is when the divorce is finalized, there is a requirement on the applicant to prove that the person that they've divorced, the husband or wife who's the European passport holder, who they no longer get on with, they have to prove that that person is working in the United Kingdom. And that is what normally causes the problem. Because if the marriage has broken down, and let's say it's been a difficult breakdown, acrimonious breakdown, you've fallen out, it's unlikely in most circumstances that the partner, in this case the European passport holder, is going to say, you know what, I'm divorcing you, but here's my wage slip, here's my bank statement, here's a letter from my employer which confirms that as at the date the decree absolute was granted, I was working. And that will assist you with your application. So that's where the difficulty arises in this retained rights application. Let me take the next call now, then return to this topic. Hello, assalamu alaikum.
जी वालेकुम सलाम. Thank you for taking my call. मेरे 3 क्वेश्चन हैं, please.
Right, okay.
I have. Sorry, can you hear me?
Yeah, sure, I can hear you. जी, go on.
Okay. So 3 क्वेश्चन है मेरे पास. यहाँ पे UK में indefinite वो stamp है. I'm working and living here.
Okay.
पहला क्वेश्चन ये है कि indefinite पे अगर मैं इस मुल्क से बाहर जाता हूँ, like America, to go there, live and work.
Yep.
So how long I can stay out of the UK?
Okay, very quick answer to that. You can stay for up to 2 years outside the UK. So as long as
2 years.
Up to 2 years. So as long as you come to the UK, even for 1 day in those 2 years, you're fine. So once you come into the UK, even if it's 1 day, the 2 years starts again. So in any one time, you can't be out of the UK for 2 years or more.
Oh, for 2 years or more, okay. Because I have American passports. Anyway, thank you. And because I thought somebody said 6 months.
No.
So I thought I'll clear with you.
No, 100% is 2 years. To be quite honest, even after 2 years, it is possible to, although your indefinite leave lapses, it is possible to apply for the indefinite leave to be reinstated. But it's difficult. I wouldn't do that. I would just make sure you come back into the UK within 2 years. And you have evidence of that as well. As in, don't lose your passport.
We'll do that. तो दूसरा क्वेश्चन सिटीजन के बारे में है कि चूंकि अभी मतलब मेरा ड्यू है citizenship because I've been in this country almost like 15 years now. My wife is a British citizen, kids, one of them born here. तो उसमें ये है कि मैंने अप्लाई नहीं किया. मैंने कहा I don't need it because मुझे किसी ने कहा था कि if you apply for UK citizenship then आपको जो अपना पहला पासपोर्ट है citizenship वो गिव अप करना पड़ेगा. लेकिन वो there was not the right information. So अगर मैं अप्लाई करता हूँ citizenship के लिए तो टाइम कितना लग जाता है, उसकी फीस कितनी है, और तीसरा
typical processing time for citizenship at the moment is around 4 to 5 months.
4 to 5 months.
You can retain your passport during that period, it's not a problem. But the typical, and you can leave the country as well, that's not a problem. But the typical processing time is 4 to 5 months.
4 to 5 months.
And fees is roughly £1,300.
How much, sorry?
Roughly £1,300.
£1,300. And उसके लिए requirement मैंने काफी अर्सा पहले I think I just gave one test. It was called like ECL, English language test or something. So do I have to take it again because I took it about maybe 3-4 years ago?
Potentially you might have to. When you look at the application form, it will. So you know the test you did. This is the easiest way to look at it. The test you did, was it at B1 level? Can you remember, or was it at a very basic level?
I'll be honest with you, I don't remember anything. I should have a certificate somewhere in my record, but it was like a while ago.
Okay. The best way to look at it is this. When you fill the form in, it will give you a date in the form when you get to the English section. If you applied for indefinite leave after a certain date, then whatever qualification that you did will be acceptable. It'll tell you what the date is. I can't remember off the top of my head what the date is. I think it is an application made after 2015 or something. Then you don't need to obtain any other English qualifications. But the form tells you you need to look at when you applied for indefinite leave. If it's after a certain date, because you've already met the higher English requirement, you don't need to do another test. If it's before that date, because you would have met a lower English language requirement, you would need to do the B1 test. But off the top of my head, I can't remember the exact date. The application form AN1 will tell you what the date is as to whether you need to do a new test or not. But normally, in terms of English, the test is Life in the UK test and a B1 test. But because some of the old qualifications were at the B1 level standard, what they've done is to say you look at when you actually applied for indefinite leave. But what you normally find is historical cases where somebody's applied for indefinite leave many years ago, they definitely won't qualify with the certificates that they used then. They will have to do the new test. But look at the cut-off date in the actual application form.
I think it was like Life in the UK test, because I can't remember even. I'll look at the certificate. Which one was it? I think it was Life in the UK.
You would have done both. You would have done the Life in the UK test, and you would have done another English test as well. But it's previously the English tests were lower. The level was lower, so that's why they may not accept that test. But so you need to look. It may be you need to do, in addition to the Life in the UK test, a B1 test in English. You might need to do it again, or do it for the first time, because you're previous.
Thank you. And one last question: do you have an office somewhere I can get the number from? Your office number from your studio?
Yeah, our office. Yeah, you can do. The studio will give you my mobile number. Our office is in Dewsbury. I don't know how far you are from there, but we're in Yorkshire, Dewsbury. But you should be able to get my number from the control room. So Jazakallah, thank you very much for your call on that. We'll take our next call. Hello, Assalamu alaikum.
वालेकुम अस्सलाम जी, आप करना था मेरा entrepreneur visa extension के लिए दिया हुआ है, और it's been 18 months now. I have given for extension and I didn't get anything from them.
Right.
And in March I'll be completing my 5 years.
Okay.
So am I eligible for my ILR, or I have to get extension first?
The best way to do it is as soon as you get your indefinite leave to remain, as soon as you get your extension, you can apply for indefinite leave to remain at that stage. That may be the best way to do it.
But till today I didn't get anything, and and I'll be completing my 5 years in March, mid of March.
I think it is unusual for it to take this long, to be quite honest. I think my view is you need to chase them up in terms of what's going on, send a letter, get your MP to write on your behalf, etc. It shouldn't normally be taken 18 months. They do take 6, 7, 8 months to be processed.
Yeah. So in between they have asked for some clearance, so we have provided that also.
Okay.
And after that there is no rejection, there is no confirmation.
Okay.
And only thing what I got is there is no objection what they have asked for my account,
okay,
which we have given from the company house.
Okay.
And so I just don't know what to do, because
okay,
I'm worried I'll be completing my 5 years.
Well, what you do is as soon as you get your extension, at some stage.
So do they give before within the period of 5 years?
Well, not necessarily. It's whenever they've managed to make a decision on it. A lot of people are in this situation where they've applied, they're getting close to the 4-year or 5-year mark. But what you should do is, once you get the decision, and hopefully it's a positive decision, let's say you get the positive decision. If you've completed 5 years already, then you don't need to wait another 2 years or 3 years. You can apply as long as you meet the requirements, you can apply straight away for indefinite leave. So as soon as you get your decision, as long as you meet the requirement and you've been here for 5 years, you submit your indefinite leave application straight away. You don't wait another 2 years.
So do we need to retain our passports from them then?
You will need to resubmit the passport when you make the indefinite leave application.
Okay. So is it possible without extension we can apply for ILR?
My understanding of the rules is that you can't do that. You have to, that first leave has to be granted. That's my understanding. You can't do that.
If God forbid, if I didn't get my extension in till March, so where I will be then?
Well, whenever you get your extension, it will be for 2 years. So let's say you get your extension in June 2018, it will be for 2 years. So it will, as a minimum, take you to June 2020. But what you will have is you will have the option at any stage to apply for indefinite leave because you've completed your 5 years already.
Okay.
So I don't think the 5-year mark is the concern here. I think what you do need is a positive decision on the extension, because I think if you get a positive decision on the extension, there won't be many queries when you make the indefinite leave application, because they've already been satisfied of your investment, of your job creation, of the genuineness of the business. So when it comes to indefinite leave, there shouldn't be any real concerns.
Okay.
So what I would do is wait for the decision on the extension. Hopefully you get it. Assuming you've then completed 5 years, make your application straight away for indefinite leave at that stage.
Okay. Okay. Thank you very much.
No problem.
Thank you for the advice.
No problem. Thank you very much for your call. Now, one of the questions that we had before, which I didn't really get time to deal with, which is one of the first calls after we had a break. Somebody's in the United Kingdom with a student visa who has potentially committed a criminal offence. I think what the caller said was that it was the friend who'd been stopped by the police for, I think, drink driving. So it was an OPL matter. And it doesn't look like the person has been charged or been convicted of anything. But let's assume that there is a potential problem here, that the person either gets charged or the person gets convicted of an offence. In that situation, the problem generally occurs not immediately, because it's unlikely that the Home Office will do anything to curtail the visa, because the penalty for those kind of offences don't normally end up with lengthy custodial sentences. Of course, they normally result in a ban from driving. So the Home Office doesn't look at curtailment of the visa, so a student can continue studying in the United Kingdom legally. The problem really occurs when somebody applies for an extension of their visa from the United Kingdom, or if they leave the country and they apply to come back again. There is something called a suitability criteria that the Home Office looks at, and that's where the problem is, that under the suitability criteria, the Home Office may look at refusing the application. That's where the problem is. Now, the outcome of the drink driving matter will really be a ban and a fine. That in itself doesn't prevent an extension, but the Home Office can still say that this person is not suitable to be granted an extension in the United Kingdom. There's a lot of flexibility that the Home Office has under the suitability criteria, and they're using different things like a TOEIC test, which the applicant, they allege, has fraudulently taken, or there could be other criminal matters which haven't resulted in custodial sentences, but the Home Office is saying that that has a bearing on your suitability, and they are using the suitability criteria, unfortunately, to refuse applications. So that's where really the problem lies. We can look at these matters in greater detail next week. Unfortunately, that does bring us to the end of the show. Inshallah, we'll be back next week on Monday at 6 o'clock. See you then.